As you know, a husband has unfettered powers to pronounce talaq at any time, as and when he wishes. But what about wife? A wife has not the power to divorce husband. So for the purpose of giving certain rights to the wife, a suit for dissolution of marriage by the wife may be filed to get a judicial divorce. Dissolution of marriage was recognized by the Indian courts, but in 1939 an act was promulgated. That act is known as Dissolution of Muslim Marriage Act 1939. It was promulgated, it came into force on 17th of March 1939. This act was passed to consolidate and clarify the provisions of Muslim law relating to suits for dissolution of marriage by wife. So it provides certain grounds whereupon the wife is declared entitled to get the decree for divorce. So a suit for dissolution of marriage is competent on the grounds enumerated in the Dissolution of Muslim Marriage Act 1939. Now this act gives certain rights to a wife that if she proves any of the grounds given in the Dissolution of Muslim Marriage Act 1939, she may seek the remedy of dissolution of marriage. So there are grounds. Suppose, as given in the act itself, that a husband is not available for the period of 4 years, meaning thereby that whereabouts of the husband are not known for a period of 4 years, then it is a good ground for dissolution of marriage by wife. A man enters into marriage contract with a wife and during cohabitation he does not maintain her, and then she is deserted from his house, and even on demand he fails to give maintenance. So the law provides that if a man fails to provide maintenance to wife for 2 years, it is a ground for dissolution of marriage. This is not the question whether a wife is a poor or a rich. Suppose a wife has its own landed property, it has its own houses, it has its own bank accounts. In spite of all these things, the husband cannot say that you have sufficient means, so I am not going to maintain you. It is incumbent upon the husband to maintain her, even if she is a rich lady. So the law recognizes that if a husband fails to maintain his wife for 2 years, she has a ground for dissolution of marriage. It happens that a husband is convicted and sentenced for a period of more than 7 years. So if a husband is sentenced for 7 years, it is also a ground for dissolution of marriage. It is another ground, this is very important one, that if the husband fails without reasonable cause to perform marital obligations, it is to be kept in mind that the marriage is meant for the marital performance of marital obligations. The wife has certain obligations as well as the husband has certain obligations. If the husband fails to perform the marital obligations, the wife may ask him to divorce her. So if he fails to do so, even then failure without reasonable cause to perform marital obligations is a good ground for dissolution of marriage. As we saw while we were discussing marriage, that marriage is a civil contract. So in this contract, the husband is bound to perform marital obligation, and the same is the case with the wife, and the wife is also bound to perform marital obligation. If the wife is willing and ready to perform, but the husband fails to do so, then in this situation, the wife may seek the dissolution of marriage, because the purpose of marriage is the creation of human beings. And if the husband fails to do that, a wife may seek the remedy, may ask the court that the husband has failed to perform marital obligation. So when the husband fails to perform marital obligations, it is one of the grounds for dissolution of marriage. There is another aspect, that a man is impotent. Then the impotence is a good ground to seek the decree for dissolution of marriage. So impotence of husband is recognized by the law as a ground. When a lady alleges that her husband is impotent, then the burden is on the husband to prove that he is not impotent. It means that the wife's allegation is sufficient if she makes a statement on oath and deposes before the court that her husband is impotent. Then the burden is shifted on the husband, and the husband is bound to prove that the allegation was false. But if he fails to prove its falsehood, and on account of his failure to prove the falsehood, the court may presume that the husband is impotent. So this presumption is a proof of the impotence of the husband. So impotence of husband is a ground of dissolution of marriage. If the husband becomes lunatic, he becomes insane, and he is unable to understand the relevant and rational questions, and he is unable to answer the material rational questions, and he is unable to understand his daily life. In the other words, if he becomes insane, so the insanity of husband is also a good ground for the dissolution of marriage. We have seen that the wife has the grounds for dissolution of marriage, but there is another aspect, that the husband delegates his power of divorce to wife, then it is itself a ground that she herself exercises this right. So when the power of divorce is delegated to the wife is entitled to divorce herself. So this is also recognized by the Dissolution of Muslim Marriage Act 1939 as a ground for the dissolution of marriage. The main question which usually crops up in the courts is the question of cruelty of the husband. The law recognizes, the Dissolution of Marriage Act, Muslim Marriages Act 1939 recognizes that a cruelty of husband is a ground for dissolution of marriage. Now, several times it happens, what the cruelty means. What is a cruelty? Though it has two parts, it is a cruelty of beating the wife, thrashing the wife, and the other part of this cruelty is the cruelty of the conduct. So cruelty of conduct is also a ground for dissolution of marriage. Actual and habitual beating is also cruelty. It is also a ground, so we will discuss it at a later time, how the cruelty of husband entitles a wife to get a decree for divorce. Any other ground recognized by the law, especially by the Islamic law, is a good ground for dissolution of marriage. So when we cast a glance, we catch sight of certain grounds recognized by Islamic law. The Islamic law recognizes khula as a ground of divorce. A husband may, a wife and a husband may have the relations, good or bad, it is immaterial. According to injunction of Islam, if you fear that they cannot lead life within the limits of God, then the wife may seek the dissolution of marriage on the basis of khula. If you fear has been several times interpreted by the courts, that you means not the husband, you means not the wife, but the you means the court, the qazi. It means if the qazi has the fear in his mind that they cannot live within limits of God, then he will dissolve the marriage. So this is called marriage dissolved on the basis of khula. Khula is a very important aspect of the dissolution. Khula means to put off the garments. To put off the garments. It means that the husband, which is a customary method, if I want to explain it in this way, that when the parties enter into a marriage contract, the husband brings a garment for the wife, and that is a proof of marriage, that the husband has given her a garment. But when the wife says that I am not going to accept it, and she puts off the garment, then it is called khula. So the attempt of dissolution is from the side of the wife. The wife says that I am not willing and ready to perform a marital obligation with this man because I do not like him. I hate him. I cannot leave him within the limits of God. So the court, if the court has fear in mind, and if the conscience of the court is satisfied, that then the court shall dissolve the marriage. Now there has occurred a development in the West Pakistan Family Courts Act 1964, that the marriage is dissolved when the court considers that the reconciliation between the parties is impossible. So the procedure which is nowadays adopted by the courts in Pakistan is that a wife files a suit for dissolution of marriage on the basis of khula. The court summons the husband comes in the court and gives his written statement. After filing the written statement, the court asks the parties for reconciliation. If the reconciliation fails, it is presumed in Pakistan that they cannot live within limits of God, and when they cannot live within the limits of God, the conscience of the court is satisfied and the court dissolves the marriage at once. So immediately the marriage is dissolved when the reconciliation fails. So this procedure has been adopted in Pakistan for the dissolution of marriage. But in earlier days, it was the conscience of the court that the plaintiff had to satisfy the conscience of the court that they cannot live within the limits of God. Then the court could dissolve the marriage on the basis of khula. Now the question is, why the wife is not willing and ready? It is her own prerogative. It is her own choice. So normally it is presumed that the act and the conduct of husband is based upon cruelty. So the wife hates him. So the hatred by the wife is a ground which is presumed in cases of khula. The wife is entitled to a decree for the dissolution of marriage if the husband treats her with cruelty. That may be cruelty of conduct, that may be cruelty of act, that may be thrashing, that may be beating, that may be abominable behavior by the husband. That is immaterial. So it may be said that it is a ground for dissolution of marriage. It may be a ground for khula, but it is itself a ground as well. Cruelty is a ground itself, and the cruelty is a ground of khula as well. If the wife comes to the court for the dissolution of marriage on the basis of khula, she says, I hate him because he is cruel. But if she does not come on the basis of khula, even then she can seek the divorce on the ground of cruelty. She may allege that the husband is cruel. So in that situation, she has to prove the cruelty. If the cruelty is the basis of khula, then the procedure which I have described before you is to be followed. But in case the wife does not claim khula, but comes in the court for the dissolution of marriage on the basis of cruelty, then the wife is entitled to a decree for the dissolution of marriage if the husband treats her with cruelty. Number one, habitual beating is a cruelty. Then the cruelty of conduct. Cruelty of conduct means she associates with women of evil repute. If the wife has the apprehension and if he tries to prove this fact that her husband has illicit relation with other ladies, then he shall have to prove it. Her presumption is not sufficient. In case of khula, she may presume and ask the court for khula, but so far as the question of cruelty is concerned, then she must have to prove it. Her presumption is not sufficient. Then she has to prove the cruelty of conduct, that this is the evidence on the question that she associates with women of, that he associates with women of evil repute. So if a husband is proved to be having a relationship with ladies of evil repute, it is also a cruelty. The wife cannot tolerate this behavior of the husband, and she, by her conduct, suffers the aspects in her mind. There are certain examples that a husband compels his own wife to lead an immoral life, and she is not willing and ready to do that. Then in that situation, if he compels her to lead an immoral life, she may ask the court that he compels me to lead an immoral life, so he is a cruel man, so I cannot live with him. But so far as this allegation is concerned, she has to prove it. Mere allegation is not sufficient, but she has to give evidence on this point that her husband compels her to lead an immoral life. There are certain circumstances when the husband commits criminal breach of trust. A wife gives him his ornaments as a safe custody. He deprives her from those ornaments and disposes of the property. So in this situation, the dispossession of the husband, dispossession of the wife by the husband is also a cruelty. So dispossession of her property or prevention by the husband the use of the property is also cruelty. There are certain circumstances when there is a difference of religious thoughts between the two. In that situation, the husband asks his wife not to perform her religious obligations. Then if the wife wants to say her prayer, the husband says, no, I shall not allow you. If she wants to recite Holy Quran, the husband says, I shall not allow you. If she wants to have a fast, the husband does not allow her. Then in this situation, the husband is obstructing her in observance of her religious beliefs. Then it is a ground. The husband is cruel. He is interfering in our fundamental right. So the law also says that it is a cruelty. If she wants to perform her legal obligations, if she wants to perform her religious obligations, the husband should not be an hindrance in her way. But There is another interesting ground that if a man has two wives and he does not treat them equally, one might may say that he is not treating me equal with that wife, the second wife, and the second wife says he is not treating me with first wife as she is treating me equally. So if she claims and she alleges that the husband is not treating equally with other wife, it is also cruelty. The law says that the husband should treat both the wives, or if he has more than 2 or 3 wives, he should treat all them equally. But if he does not treat them equally, any wife who has complaint against him may seek the dissolution of marriage. So the Dissolution of Marriage Act 1939 gives the ground for dissolution of marriage to a wife. And these all are not to be proved. Any one of these grounds is to be proved. If any one of these grounds is proved, she is entitled to a decree for dissolution of marriage.